Welcome to the Explainer. India's new data privacy law, the DPDPA, was supposed to be our shield, protecting our personal information. But in a pretty dramatic twist, the law itself is now on trial, facing a huge challenge in the Supreme Court that could literally rewrite the rules for digital privacy for over 1 billion people. So, how in the world did we get here? Well, the DPDPA became law back in August 2023, but it wasn't long before the lawsuits started flying. By March of this year, the fight reached the Supreme Court, which has now officially put the government on notice to defend its brand new law against some very, very serious accusations.
Now, according to the source material for this explainer, this isn't just some dry legal fight. The argument is that there's a coordinated campaign happening in the background, one that's using the media to shape public opinion against the law before the court even gets a chance to hear the full arguments.
To really get to the bottom of this, we're going to break it down into the 4 main battlegrounds. First, are the law's basic building blocks just too vague? Second, does it give the government way too much power to spy on us? Third, does it totally gut our right to information? And finally, if your data gets breached, who actually gets the money?
Okay, let's dive right into this first major challenge, the accusation that this whole law is built on a really shaky foundation of unclear, undefined terms.
The argument here is actually pretty simple. If you can't even clearly define what personal data is, how on earth can you protect it? Critics say this isn't just some minor flaw, they say it makes the entire law unworkable from the get-go.
But the rebuttal goes straight to the source, the law itself. Right there in Section 2T, defines personal data as any information that can be used to identify a specific person. It's a broad definition, sure, but it is a clear one.
The argument from the source is that, look, this isn't some brand new concept. The DPDPA actually builds on definitions from the older IT Act. Basically, if you've already made your data public yourself, it's not covered. And if it's not personal, then it's non-personal. From this point of view, the whole accusation of vagueness just kind of falls apart. Now, for what might be the most explosive charge against the DPPA, the idea that it's not about protecting us, but about giving the government a green light for mass surveillance. The big worry here is that the government has basically given itself these incredibly broad exemptions. Petitioners argue that by using reasons like national security or public order, the state gets a blank check to demand anyone's personal data, effectively legalizing disproportionate surveillance. And this right here really gets to the core of the disagreement. On one side, you have this fear of a surveillance state with unchecked power. But on the other, the argument is that these government powers are actually very specific and are limited by the exact same constitutional rules that apply to things like freedom of speech. Our source pushes back hard on this disproportionate surveillance claim by pointing to several built-in safeguards. See, these exemptions don't apply to the whole government, only to specific named agencies. They can only be used for clearly defined reasons, like national security, and the officers who use these powers are held accountable. The idea is that it's a system designed to balance our right to privacy with the state's need to ensure security. All right, next up, let's look at how the DPDPA might affect 2 absolute cornerstones of Indian democracy, the Right to Information Act, or RTI, and, of course, the freedom of the press. This is a huge, huge point of contention. Activists and journalists are really concerned that by changing the RTI Act, the DPDPA has basically slammed the door on a vital tool for uncovering corruption. They're calling it a blanket ban on getting personal information even when it's in the public interest. But here's the counter-argument from our source. This change wasn't a choice, it was mandatory. Think about it. After the Supreme Court's huge 2017 privacy ruling, and with the DPDPA bringing in heavy fines, public information officers were suddenly facing massive legal risks for releasing personal data. So the key point here is that this amendment was needed to protect those officials from getting sued. And what's more, the source argues that the heart of the RTI system is still beating. You can still appeal a decision if you're denied information, and journalists can absolutely still take the government to court to fight for the release of that information. Okay, let's get practical for a minute. If a company leaks your data, what happens next? Do you get any compensation? And who's the watchdog making sure everyone is even following the rules? A major criticism is this idea of a compensation vacuum. So while the government can hit companies with massive fines for data breaches, the actual individual whose privacy was violated gets nothing. The source calls this one of the most childish charges, explaining that the DDPA is designed to be a deterrent. It punishes companies. It actually works alongside the older IT Act of 2000, and that's the law that already gives people the legal path to sue for personal compensation. So you have two different laws with two very distinct jobs.
And what about the regulator? The worry is that this new Data Protection Board, the DPB, won't be truly independent, that it'll just be a puppet of the executive branch. The rebuttal, though, points to a very clear appeals process. The Data Protection Board is just the first stop. If you don't like their decision, you can take it to a specialized tribunal and from there all the way to the Supreme Court. That creates a really powerful system of judicial oversight, making sure the board can't just do whatever it wants. At the end of the day, the source's position is that, legally speaking, you can't sue a board for being biased before it even exists. Criticizing what its future members might do is just speculation, not a legal argument that a court can rule on right now. So, what's the big takeaway from all this? The central counterargument we've walked through is that these legal challenges are looking at the DPDPA in a vacuum. They're failing to see how this new law is supposed to fit together with India's constitution and a whole web of other existing laws, like the IT Act and the RTI Act. And that leaves us with this final and pretty provocative thought from the source. The DPDPA might not be perfect, but this constitutional fight might be happening too soon. The question of whether the law could be better, well, as it says, that's a debate for the future.